section of our rules, specifically the safekeeping of funds and other property. This section of the rules makes up 2 to 8% of your total exam. The first rule that I want to point out is the safekeeping of funds. The rule states, when a client prepays a lawyer for services or otherwise gives a lawyer property, the lawyer is supposed to keep it separate from its own and not steal it or borrow it or use it for their own personal advantage. So that's the general rule. If your client gives you money, maybe as a retainer, to prepay you for your services, you can't use it like your own. It's supposed to be separate from your own money or your law firm's operating account. You can't borrow it and then pay it back. Thus, the essence of this rule is that it's their money and not yours. On that note, I want to give you a quick tip. Be on the lookout for a no harm, no foul like answer choice. Oftentimes, they'll tell you that a lawyer has borrowed money from a client without permission, and the client never finds out about this because the lawyer pays them back before they ever had a chance to know that it was gone. And ultimately, the client isn't harmed. But that doesn't matter. Remember, if there's a rule violation, there's a rule violation. It doesn't matter that the client wasn't harmed as a result. So, a few things to keep in mind about this rule. Be on the lookout for fact patterns that discuss large sums of money versus a small sum of money given to the lawyer by the client. And that's because the rules are slightly different as it relates to each. When it comes to a large amount of funds, the rules state the lawyer is supposed to put that money in a separate interest-bearing account and allow the client to retain the interest. Why? Because if it's a large amount of money, they should get any interest earned on it. It's their money after all. When it comes to a small amount of funds that a client gives a lawyer, the rule states the lawyer should put those funds in a pooled client trust account. All states have what we call interest on lawyers' trust accounts, or an IOLTA for short. Usually the interest earned on that fund goes to a state bar or some sort of legal foundation, and it's used for public use. So again, to recap this rule, if your client gives you a small amount of money, you can put it in a pooled account with your other clients' monies that have also given you that small sum. The rule goes on to discuss location. A client trust account must be held in the state where the lawyer practices or elsewhere with the consent of the client or a third person. So if you practice in Michigan, your client trust accounts should generally be held in Michigan. As it relates to other property, if a lawyer is entrusted with their client's property, they shall identify it as such and appropriately keep it safeguarded. Further, complete records of such account funds and other property shall be kept by the lawyer and preserved for a period of 5 years after termination of the representation. So, for example, if your client gives you a diamond ring to hold on to, then you need to identify it as the client's and appropriately safeguard it. In other words, don't put it in your own personal jewelry box with your own personal assets. Instead, this is likely the type of thing that would be kept in a safety deposit box and in probably some sort of container that further identifies it as your client's property. So when it comes to client trust fund accounts, the rules tell us that any money that a lawyer receives but has not yet earned, so I think of this like a retainer or some sort of upfront deposit, then the lawyer has to immediately take that money and put it into a client trust fund account that is separate from its own personal account and that's separate from the law firm's operating account. Remember, we're keeping the client property completely separate, so there's no commingling of assets. And further, the rule states that lawyers are not supposed to put any personal money or law firm money into that client trust fund account, because doing so would amount to the commingling of assets, which we know is a rule violation, unless the money being placed in this client trust account is for the sole purpose of paying bank charges on that account. But the rule makes it clear that you're only ever allowed to deposit as much money as is necessary to cover those types of bank charges. So let me give you a quick example. Let's say your client gives you $15,000 as an upfront retainer, and you deposit it into your IOLTA. The client's case starts to progress, and you realize very quickly that there's not enough money in that account to cover bank fees and the expert witness fees. So you decide to put some of your own money into that account to make sure that everything gets covered. Have you done anything wrong? And the answer is yes. While you're technically allowed to put in the exact amount of money necessary to cover those necessary banking charges, you're not allowed to otherwise add in your own money. So while this distinction is very small, it's nonetheless a distinction that you should have on your radar. We know what we're supposed to do with client money, but what do the rules say about withdrawing it? Well, the rules tell us that you can withdraw funds only as you've earned your fees or only as expenses are incurred. If you think about the general idea behind this rule, then this portion of it makes sense. A lawyer's client's money is not the lawyer's, it belongs to the client. The lawyer is just holding it in trust until they have to pay out expenses on their client's behalf or pay themselves for fees that have been incurred or earned. Now, what if there is some sort of disputed claim? Which, by the way, is always the question on the MPRE. If there's a dispute, the rules state that the lawyer is supposed to keep the amount that's in dispute in the client trust fund account until that dispute gets resolved. The lawyer shall promptly distribute all portions of the property to which there is no dispute over. So let's break this down. Let's say your client gives you a $10,000 upfront retainer, and you work on their matter and you successfully resolve it. You ultimately bill your client $8,000. The client says, I don't think I owe you $8,000. I think I only owe you $7,000. So what should you do? Well, pursuant to the rules, first, we're supposed to hold whatever is in dispute in that client trust fund account, and then we distribute or disperse the rest. So, at a minimum, your client agrees that you're owed $7,000. So, you're going to pay yourself the $7,000. The dispute is over $1,000. So, you'll hold that amount in trust. And then finally, you're going to give back to your client what you both agree, at a minimum, is your client's, which is $2,000. Additionally, another thing I want to point out about this rule is what are lawyers supposed to do when third parties are making claims against their client's money? I would advise you to follow the general rule we just discussed. Hold the amount that's in dispute in trust until the dispute gets resolved. So let's say your client won $800,000 in a personal injury settlement, and a credit card company of your clients finds out about this lawsuit, and they contact you and they say, hey, your client owes us $10,000. And let's say their cell phone provider also reaches out to you and says, hey, your client owes us $2,000. What you should do is circle back to your client and let them know about these claims. Hopefully, your client simply allows you to pay those bills on their behalf. But if your client says, don't pay the cell phone company, then you should hold the amount in dispute until this dispute between the cell phone company and your client gets resolved. So that wraps up this section of the safekeeping of funds and other property.